Mr. Stratton, you may address the jury.
Thank you, Your Honor. What did the prosecution want Jessica to do today? What do they want her to do through this whole trial? They want her to take responsibility. Responsibility for putting her son in this. She's doing that. She's doing that today. She's doing that in front of you. She could have pled out to this indictment. She could have got rid of this case right off the bat. But she didn't. She wanted here today, as I told you in opening statements, as you heard up on the stand, when I asked her, did you murder your son? She said yes. She says she put him in this coffin and placed him in that well. Three of these injuries are healing injuries, and they did happen before March 27th. But the major injuries that caused Dylan's death happened on March 27th. He died on March 28th. You heard her say that. And after that, this is what they did. She's owning up to that. She was forced to come here to try to save somebody who did not do that, that did not kill Dylan. She's here. She was up on that stand. All that was not to save herself. All this week is not to save herself. It's to save him because she knows the truth and she's told it. How do we know that this baby died on March 28th? Let me explain some of the testimony. Dr. Hudson said there was two visits. There was one on February 7th where the baby's linked with 19.5 inches. There was one a couple of weeks later where he was 20.3 inches. Dr. Brown stood up on the stand and said during the autopsy he was 20.5 inches, 0.2 inches longer than he was on February 21st. We know that Patricia Kraft has testified that he was alive on the 28th, so he must have died that day. Andrea Bowling testified that she wasn't surprised that Patricia Kraft or Children's Services didn't put all notes into the activity logs. You heard Patricia Kraft testify that she didn't pick him up and look at him. She merely glanced at him. Daniel Jr. himself testified that he hadn't seen Dylan 3 or 4 weeks prior to his removal from the house on April 24th. All that points to that March 28th day, the same day that my client, Jessica Groves, claims that he died. Daniel Groves, prosecution kept saying foolishly unaware. Yes, he was foolishly unaware. She took great care of Daniel Jr. You saw that up on stand. She was a great wife for all these years. Great. She's not using her drug addiction as an excuse, but that she went down that wrong path, which led us to here. The coroner herself said that she couldn't tell what the bruising was, whether it was decomposition or bruising. Dr. Hudson testified to the fact that any skull fractures might not be bruising, there might not be bruising or swelling. I present to you that the state has not provided enough evidence that Daniel was guilty of the murder. I present to you that they have failed to even give you a date of death. I have given you a date of death from the beginning because that's the true date of death that my client has testified to. I'm not much about theatrics, but my client has told the truth. What more can anybody ask for? What more can you ask from her than the truth? She's up on stand. She tried and tried. It's easier just to sit back in that chair. And before the state starts tossing this around to you to get your attention, remember, she took the blame. Thank you, Your Honor.
Mr. Stratton, Ms. Scott, you may address the jury.
Thank you, Your Honor. Ladies and gentlemen of the jury, as I began by thanking you at the beginning of this case, I'm also following up on Ms. Hutchinson. I'm going to thank you at the conclusion of this case. This has been a taxing week. This has been a trying week. This is a terrible subject matter, no matter what way you cross it, no matter what way you label it. No one wants to be here discussing this. No one wants to be involved in discussing this. I know that we're not enviable of your position in having to render a decision in this matter, but that's the oath you took. That's the oath you took at the beginning of this case. You took the oath to listen to all of the testimony, that you're not going to base your decision on emotion, that you're going to base it on the facts and the testimony that were presented during the course of this trial. And that's what I want to hold you to do. Not any of the theatrics that you saw, not any of the things that you're not supposed to take into consideration. We're holding you to the fact that you took an oath, that you're going to weigh everything that you heard, saw, and read for what the judge is going to instruct you on what the law says, and make your deliberations solely on that. So let's talk about a little bit about what you heard over the course of the week. You heard from Children's Services. You heard from doctors. You heard from nursing staff. You heard from medical staff. You heard from experts. You heard from lay witnesses. You heard from law enforcement officers. You heard from the party's child. You heard from the parties themselves. It's a lot. So I just ask that you also weigh their credibility, as the state has instructed you to do, and take all of those things into consideration. So let's break it down a little bit. You heard a lot up front on medical staff, and we started out by discussing when baby Dylan was born. The day he was born, you heard in the discussion of the demeanor of Jessica Groves. You heard how she was not cooperative, she was distant, she was standoffish. You heard all of those things comments made about Jessica Groves. You also heard that Daniel Groves tried to be cooperative with the staff, that the nursing staff that came in here and testified, her words were she felt like Jessica was intimidating Daniel because he would look to her for answers when he felt like he should answer their questions and she wasn't. Shortly after birth, there was a big deal made about whether or not he went to the nursery, didn't go to the nursery, but we also heard from staff that he went to the nursery while the baby was still on oxygen, and he was off of oxygen within an hour and a half of him coming into this world. You take that time frame into consideration for what it's worth. I don't know that I would call that a short time or a long period of time, but you also heard testimony from Daniel himself that he was instructed by staff, hey, there's medical issues we need to clear up and we need to remedy. We'll let you know when you can come on down to the nursery. And he did make his way down to the nursery within an hour or so. You heard from the nursing staff that he asked appropriate questions, that he participated, that he seemed attentive to the child, but he also was attentive to his wife back in the room who was, just gave birth. So it's a choice between being with your child, being with your spouse. He chose to be with his spouse for a while, and then he chose to be with his child. Medical staff had both of them, so it's Solomon's choice, I guess. Do you go with the baby? Do you go with your spouse? He made that choice. I don't even know if that even comes into play in your deliberations or not, so take that for what it's worth. The other part that we heard from in regards to medical staff was that there was this conclusion drawn that my client was on something. Later on that day, when she encountered him before she got off work around 3:30 that day, she did not see him take anything. She did not smell the odor of marijuana on him. She really couldn't give you any drug that would be out of the system within a mere hours. I don't know of any drug that would be out of your system in mere hours. When he took a drug screen for Children's Services that evening, that screen was negative. We heard how they conduct their protocol. We heard how they take precautions to make sure that the drug test is accurate. They use a temperature gauge cup. They make sure that the temperature is appropriate. They take precautions to not have someone in the restroom with them, not have them flush the toilet, the urinal, run water, and then that's when they make a determination on whether or not the drug screen has a positive result or a negative result. That drug screen was marked as negative in the Children's Services records that Patricia Kraft talked to you about extensively. There was no one here presented by the state to negate that that test was conducted improperly, or that sample was given improperly, or that was an improper drug screen. Heard nobody say that it was not. I'm not out here to make Children's Services the villain. Caseworkers have jobs to do. They have protocol to follow. And in this case, you heard that when baby Dylan was placed back with my client, they maintained custody, but that they made a determination based on my client passing a drug screen, or drug screens actually by that point in time. He had no previous involvement with Children's Services, and that he had no violent criminal record. You also heard from Patricia Kraft that she saw the baby on that 7-day visit, and also on 2 more visits, I believe. She testified that she saw the baby. She remarked in her notes that all appeared well, the home appeared well, the parents appeared well. She did not observe anything, although she did say that she could not see the back of his head. She did say she saw his forehead up until mid-forehead upwards. As of when she was there in February, in January and February and March, she did not observe a deep purple bruise coming down to right above his eye line. That was nowhere remarked. So you need to take that testimony for what it's worth. She saw the child over a period of occasion. That purple bruising was not there. We also heard from Dr. Hudson. Dr. Hudson saw this child on 2 occasions in February. He saw this child on February the 7th and also on February the 21st. He indicated that the child appeared well, that there were no other issues. The parents, both parents brought the child in. Other than this weird look after this prayer, not really sure what that was about. He wasn't really sure what that was about. I don't know that really has anything to do with this case. And you all take that into consideration how you feel. But he testified that he believed that they originally were doing everything that he had asked them to do, that the baby was gaining weight, the baby was growing in length. He noted on the February 21st visit, the baby was 20.3 inches. He also testified a little bit in regards to what outward signs we might or might not see if a child had received a fracture. He testified there may not be any signs on the outside, may or may not be any swelling, may or may not be any bruising. It depends on what the type of injury it is and how the child reacts to it. So please take that all into consideration as well. We did hear from Andrea Bowling. That was a very emotional testimony. I believe, ladies and gentlemen, that testimony was to invoke emotion only. It was to invoke a sense of outrage, that she had nothing to add in regards to the evidence of this case that would lead you to be finding a guilty or a not guilty verdict in this matter. I would ask that you completely disregard that as nothing but causing pure emotion. And remember, once again, you took an oath not to base your decision on emotion. You made your oath to make this decision based on the facts and testimony you heard throughout this case and applying them to the law that you will be instructed on at the conclusion of this case by the judge. That and that alone. We heard from the coroner, Dr. Susan Brown. She gave an opinion when I asked her if the baby was deceased prior to going down the well. She said yes. Ms. Hutchinson got up here and told you that she said that she doesn't know whether the baby drowned or not drowned. I believe that she was very clear when I asked her about that same or a similar question. She had the expert opinion that the baby was deceased prior to going down the well, that the baby was not alive at that time, which means that the body was merely being disposed of at that time. That was not a manner or a cause of death. She did say that the cause of death was by homicidal violence, but she can't tell you who did it. She can't tell you who caused those injuries. She can't tell you who caused any of the healing injuries. She can't tell you who caused any of the injuries that were not healing. She can only tell us merely that there was a healing skull fracture, 2 healing rib fractures, and that there were injuries that were not healed or showed signs of healing. She cannot tell us in any way, based on her expertise, who caused those. She did not give us a date of death. She did tell us that his body length was 20.5 inches. I would ask you to take that into consideration with what education that you do have and what you're able to consider, that a difference between 20.3 inches at his last doctor's visit in February 21st and when the body was examined in June of 2019, that he was only 20.5 inches, that the growth of 0.2 of an inch, if my math is correct, is not very much growth. So we would advocate, or I would ask you to find that the baby was not alive for very much longer, and that his date of death would be somewhere around March 28th when our clients purport that he passed away. Just like Dr. Hudson, Dr. Brown also testified that not all injuries cause outward signs of bruising or swelling. Both do agree that there would be some pain and some crying associated with it from an infant of that size, but at some point in time, that pain and that crying would subside. In addition, and I don't think there was a lot made of this, but at the last pediatrician appointment, the baby weighed so many pounds and so many ounces. The baby weighed significantly less than that, and that mass could have been lost as part of the decomposition of the body. Otherwise, Dr. Brown testified that the baby appeared well-nourished and developed. That is directly from her autopsy report under the section labeled external examination, and you heard her testify to that as well, and you can make reference to that. We heard from the Otway Fire Department gentleman, Mr. Gamble, who testified. He's the ones that encountered law enforcement as they were coming out of the field. He actually went to school with my client. He recognized my client. My client was there with law enforcement cooperating with the recovery of the body. Jody Conkle testified that my client eventually became cooperative. He did tell them where the body would be located. She testified, and she testified for at length. My client's not going to dispute the fact that he was not cooperative to begin with. He was afraid. He didn't know what kind of charges he was facing. He was sick. But he did become responsible and own up to what had gone on here, that he told them where the body was, and he did that within a short period of time of his arrest, or what I would call a short period of time of his arrest, a couple of days after he got himself collected. He could have exercised his right to talk to counsel. He would have been given every bit of that right and luxury. And in fact, I think you heard her say, and it was part of the listening aid, his rights that he had gone over. She goes, I know you're probably sick of hearing these by now, but I've got to tell them to you anyways, basically every time I talk to you. So he'd heard them on more than one occasion, especially if it was to the point that he might be sick of hearing them. He could invoke his right to an attorney at any time, stop speaking with her, and he did it. He spoke to her. He owned up to it. He owned up to what his responsibility was in that, and that's what he's owned up to as the course of this trial has gone on. We heard from Daniel Jr. That was also very sad and emotional testimony. Daniel testified that he saw baby Dylan bruised when he was pushed on that a little bit. He did say that it was on his scalp area where his hair would be, but he couldn't date when that occurred. He said that he originally thought it was 2 or 3 weeks prior to him being removed from his parents, which we know the date of that is April the 24th, through multiple forms of testimony. But he really was not committing to that date. So it was sometime prior to him being taken. And once again, we do know that Patricia Kraft saw this child on March the 28th, and he did not display that type of bruising. And remember, she commented to you that her comment was, I wonder if he's going to have curly hair. So she did observe the child, at least from the front of the scalp forward, or front of the forehead forward. Then we heard from the parties in this case. You heard from Jessica Groves. You may not have heard what you wanted to hear from her, or as much as you would like to have heard from her. You did not hear full explanation from her, but you did hear her take responsibility for causing Dylan's death. her and her alone. Daniel did not cause Dylan's death. And that's the most important takeaway from all of this, ladies and gentlemen. Daniel Groves got up on that stand. I think he was as forthcoming as possible. He was as truthful as possible. He was as transparent as possible. He knew he was going to be asked about some ugly, ugly things. He tried to give you the best explanation possible. He tried to own what he was responsible for owning. He may not have had the best answers for every single question he was asked, but once again, that's your job to judge that. He did adamantly deny participating or causing any of the injuries that would resulted in Dylan's death. We heard him talk about the behavior of Jessica that potentially had caused some injuries or some concerns. Did he make necessarily the best decision in all of that? He did what he thought he was doing at the time. He inspected the child. He did not see any injuries on the child. He did not see anything that needed to be taken care of immediately. Nothing that would have made him suspect that the child had broken ribs or the child had a skull fracture. And those had taken place sometime prior to this March 27th, 28th date. He did take responsibility of disposing and helping dispose of Dylan's body. But ladies and gentlemen, that's all he did admit to. That's all the participation that he did take place in. He did admit to the use of drugs. He did admit that he was under the influence of drugs when he came into custody in the Sheriff's Department in June. He admitted to you his life fell apart. His life fell apart. His baby had been found dead. He wasn't really sure what caused the baby's death. But through the fear that Jessica caused him to feel that he was going to be blamed, he decided to help her dispose of that body, not reveal it to authorities, not reveal it to anyone, not even their other child, what had happened to him. But his life did fall apart. Dylan passed away. Daniel was removed. He turned to illegal substances. But he admitted that happened in the beginning of May. And remember, Dylan passed away at the end of March. Daniel was removed around April 24th. His life fell apart. He felt like he was going to be blamed for Dylan's death. And remember, they've had this relationship for a very, very long time. You heard how, remember back in the hospital when Dylan was born, the nurses told you she gave him a look and he would not say anything. So what if she was actually telling him, not looking at him, but what if she told him, I'll blame you for this. You're the one that Children's Services entrusted with this child. You're going to help me here. I don't know what I would do in that situation. I don't know that you know what you would do in that situation, but we do know what he admitted he did in that situation. May not be the decision that we agree with, but that's what he told you happened. That's what Jessica told you happened. Ms. Hutchinson got up here, and first of all, Mr. Tiemann questioned my client on cross-examination, and he confronted him many times in regards to witnessing Jessica. hit the baby, strike the baby, where the baby was struck at, how many times the baby was struck. It was 4 times. Whether the baby was smacked, whether the baby was struck and caused fractures or injuries. Ms. Hutchison got up here in her closing. I wrote down, he bashed him in the face, bashed him in the head. I don't think we quite heard that in the testimony, either from Mr. Crows or in the form of the question asked by Mr. Tiemann. But Daniel did tell you that he did check the baby for injuries. Nothing was apparent, and there was no suspicion that the baby had suffered injuries. He did his best, and so, ladies and gentlemen, you'll just have to take that for what it's worth and make that determination. You also heard reference to how he was oblivious to things, how he was foolishly naive, and that how could he have not known he was pregnant when even Daniel Jr. confronted his mom was pregnant. But if you remember back to his testimony was he confronted his mom in November. Daniel by that time knew she was pregnant, so I think he actually knew before Daniel Jr. confronted his mom about being pregnant. So once again, please take all of that into consideration, when he knew, when he didn't know, when Daniel knew, when Daniel Jr. knew, when Daniel Jr. didn't know. Make sure you check your memories, your notes, all of those things, and reflect on what you actually heard here today, not what you were told you heard here today. Another point that I would like to make is that there was nothing in the evidence about my client being high or under the influence of any drugs until he came into custody on June the 10th of 2019. Nothing. There were no drug test results. There was nobody that came in here and told you that he was high or under the influence other than one nurse who suspected, without any confirmation, suspicion's not evidence. She never saw him do anything. There was no testimony that anybody saw him do anything. There was no testimony or evidence that he faked any of his test results. It was not until after baby Dylan had passed away, Daniel Jr. had been taken, his life fell apart, and he gets arrested, and we do have his own admission that he started using in May of 2019. Ladies and gentlemen, I know you're going to get the judge's instructions, but I just wanted to point out a few things. You are able to look at direct and circumstantial evidence. I did not hear anything. There was no eyewitnesses. There's no camera footage. There's nothing that we would think of when we look at the example of Johnny ate the cherry apple pie, I think was used in this case, when you were when voir dire was being conducted and you were being reminded about by Mr. Tiemann about what evidence that you will be able to take into consideration. There's no one that came in here and testified that they saw my client strike this child, cause injury to this child, cause him harm in any way, directly. Circumstantial evidence, that's the one where you have the child sitting in the room, the center is ate out of the pie, there's pie crumbs, pie filling all over his mouth. I don't think we have that here either, ladies and gentlemen. You heard Mrs. Groves deny that my client participated in these acts. You have my client deny that he participated in these acts. but you follow what the judge instructs you to follow, and you compare the facts and the testimony that you heard here today. Also, the example was given, I believe, back at the beginning of this case, about the one holding the ladder while the one goes in the window. I purport, ladies and gentlemen, the client was not holding the ladder here, not watching his wife climb in the window. We do not have that here. You will also, that goes to complicity. And the judge is also going to instruct you on complicity and what that is. And the important things are aiding and abetting. And you will have a definition of what aiding and abetting are, or what conspired means. You all are going to be the finders of fact, and whether or not the testimony meets the definition, that my client supported her in doing this, assisted her in doing this, encouraged her any way of doing this, cooperated with her, advised her, or incited her to do that. Ladies and gentlemen, I would advocate that you did not hear any of that testimony. Once again, you cannot base that on pure outrage and emotion, what you think should happen here. It's what did you hear happen here. Conspired with the purpose to commit, promote, facilitate the commission of the offenses. Once again, I would advocate that you did not hear testimony that would match that definition in this regard either. Once again, don't let emotion run the day here. That you have to hold yourself to your oath. Hold yourself to what you heard. Hold yourself to the instructions. The state has the burden here. Mr. Tiemann started this case right out of the gate, told you they have the burden. They're the ones that has to take it over the goal line. The judge will clearly instruct you on what the burden is. Hold them to that standard, ladies and gentlemen. Hold them to that standard. That's the oath you took. Please hold them to that standard. I believe that if you do hold them to that standard and you take everything into consideration that you've heard, seen, read, not heard, seen, or read, not base any of this on emotion, throw all of that out the window. I know it's going to be hard to do. That you're going to return and render a fair and just verdict in this case, and that's what I'm asking you to do. Render a fair and just verdict. Render the verdict that is merited based on what you've heard, seen, or read, and what matches the law that you're going to be instructed on. Thank you.